Legal recruitment process. Introduction to the module. This module will teach you what the Equality Act 2010 is and how it relates closely to the recruitment process. The importance of a lack of discrimination in the job application procedure is also explored. Topics to be covered: Recruitment and the Equality Act 2010. Ways to avoid unlawful discrimination in recruitment. Employers' legal duties. Employees' duties. The main legal issues. Advertising for a job. Application form. Shortlisting. Interviews. Adjustments for candidates with disabilities. Selection. Automated decision-making. Making an offer of employment. Carrying out checks on potential employees. Restrictions on the employment of children and young persons. Employer's Guide to Criminal Record Checks. Recruitment and the Equality Act. An employer must learn to make fair and unbiased decisions when hiring staff for their workforce. They must look for a candidate who provides the skills they need for the job and not be influenced by any misconceptions or prejudices. Recruitment. Like any important business plan or strategy, staff recruitment needs to be carefully considered, not based on hasty decisions. When a company advertises vacancies, discrimination, whether intentional or not, can be incorporated into the hiring process. Ideally, a recruiter or employer should judge an applicant on their skills, knowledge, and experience. The characteristics of the Equality Act 2010 protects. The Equality Act 2010 is an act of Parliament that was specifically designed to unify and update all the previous laws and regulations involving anti-discrimination in the UK. It provides the groundwork for all cases claiming discrimination and allows individuals to be free from bias in the employment sector and provides vital guidelines for employers and employees alike. The Equality Act specifically states that the following characteristics should not be discriminated against during recruitment: age, marital status, pregnancy and maternity, having a physical or mental disability, race, including color, ethnicity, or nationality, religion or belief, including those who do not practice one, sex or gender identification, sexual orientation, gender reassignment. Ways to avoid unlawful discrimination in recruitment. It can be all too easy to place discriminating text or information in the text for a job vacancy, which may suggest that employers are looking for a very particular type of person when that is not necessarily the case. Therefore, it is advisable to check recruitment details to prevent unlawful discrimination when recruiting staff. Job title. Always ensure that this is gender neutral, and do not use old generic titles that suggest it is being targeted at just one sex, for example, postman, fireman, etc. Job description. The description and requirements needed for a job must be carefully reviewed or updated. If it can be successfully carried out by a person with physical disabilities or any gender, then this should be made clear in the recruitment process to prevent any confusion and ensure equal opportunities. Job duties. The duties and experience required for performing the job should be open and honest, and should not assume the gender, race, or physicality of the person who may apply. Occupational requirements. Under the guidance of the Equality Act, it may still be appropriate to specify gender, race, or religion. This is acceptable if someone with that characteristic is essential for that job. For instance, a job involving the support of a mosque or church would likely benefit from a person applying with the appropriate faith or beliefs. Person specification. Like occupational requirements, an employer should not infer a preference for a certain type of person to apply for a role. Unless this can be proven beneficial to the job, any specification stated within the application process will be unlawful. Age. The Equality Act also recommends that an employer does not overestimate the number of years of experience that a job requires. This ensures that younger candidates can be considered. They are also encouraged to consider older candidates equally, especially with default retirement ages being abolished. Ability to speak fluent English. It is imperative that an employer honestly reviews a role to understand the relevance of face-to-face communication. An important role can require frequent interaction with UK customers or clients. However, this may not be true for many other important jobs or vacancies. The UK government has a statutory code of practice to help employers understand this. Flexibility. Some employers may request that candidates for a job show flexibility, which can either mean more physical labor, additional duties, or unsociable hours at short notice. This should only be emphasized if it is a true and unavoidable part of the role. Unnecessary use of unsocial hours is now seen as discriminatory against people with children and can be challenged. Full-time working. Employers need to consider if a vacancy could be fulfilled with part-time employees. This is to prevent discrimination against candidates who may be perfect for the role but have responsibilities as parents or carers. Unless the full-time work is genuinely necessary, it could introduce flexible working and a healthy work-life balance in the company. Employees with over 26 weeks of service have the legal right to request flexible working conditions. Skills and experience. While certain levels of skills and experience may be desirable for an employer when recruiting, they should also be honestly reviewed. Requirements such as a university degree coupled with 5 years' worth of experience in the appropriate field eliminate a large section of possible candidates. This can easily be viewed as discrimination against those of younger years or other nationalities. Employers' legal duties. With the guidelines from the Equality Act explained, an employer has several obligations to obey the law. These considerations and details include: all applicants must be treated the same regardless of their gender identification, age, disabilities, race, religion, sexual orientation, marriage, and parental status, or union membership. Full reasoning must be given if a specification, age, gender, religion, etc., is indicated for a job post. Checking on candidates intending to work with children and vulnerable adults must be subject to DBS, disclosure, and barring service checks to ensure suitability and safety. Ensuring candidates are prepared to observe the requirements of the Data Protection Act when working in relevant areas. Job roles must be reviewed to ensure that they are not unnecessarily discriminated against a section of applicants. Consideration must be given to adjusting job requirements to allow a disabled person to apply. Ensuring that candidates with previous criminal convictions are treated appropriately. Applicants should never be pressured to join a union or organization to apply for a job. They remain aware that they can be liable for prosecution if they display discrimination towards any applicant. Checks must be made to ensure that applicants have the right to work in the UK and do not contravene any other laws involving age, criminal activity, or health. They agree to the recruitment and selection process being monitored as required by the Equality Act. Employees' duties. Employees have obligations during the recruitment process as dictated by the Equality Act. These include complete honesty and openness with the personal information they provide, obeying the requests and appropriate check procedures given by the employer, declaring the existence of a criminal record, providing relevant documents and proof of identity evidencing the right to work in the UK, providing the names of suitable referees. abiding by any agreement they make with the employer. Advertising for a job. When advertising a job, an employer and a business must promote equal opportunities. This means they should consider everything from group photos. Do not use team photographs that display people from the same race, gender, and age, and the text of the advert. Adverts with wording such as adventurous and go-getting could deter those with disabilities, whereas mature and experienced might repel potential younger candidates. An advertisement should always be an equality exercise that can reflect a business's positive aspects or reveal its shortcomings. Application forms. The equality law also affects job application forms in the following ways. All information recorded on a form must be treated as confidential. Alternatives to a printed or online form should be made for those with physical disabilities, braille or audio contracts. Personal data should be recorded on a tear-off portion of the form, and this should only be used for monitoring purposes, not information for selection. Personal information about the health status of the candidate should not be requested unless there is good reason. Some personal information should be regarded as off-limits, for example, data regarding an applicant's child, unless there is an excellent reason for recording it. Employers should not use application forms to request and store personal data for recruitment purposes or archival purposes. This is following the General Data Protection Regulation (GDPR) and the Data Protection Act 2018, which will be fully covered in Module 11. Personal data can only be utilized for larger exercises with the express consent of the provider, and an application form is not the place to do it. Forms should include a declaration that the data submitted by the candidate is true and complete. Shortlisting. Once all the candidates have submitted their details, shortlisting the prospective employees can begin. But employers should still ensure that discrimination does not play a part in the process. They can do that in the following ways. It should be performed carefully and consistently, and only against the objective criteria set out in the job description. Awareness exists that a decision not to shortlist someone can be later challenged under discrimination law at an employment tribunal. But if the employer has obeyed the equality law, they can successfully defend themselves. Records are kept of the criteria under which the applicants are shortlisted or rejected. Interviews. Anti-discriminatory behavior should continue throughout the recruitment process and especially during any interviews. This can be achieved by being aware of possible prejudices and stereotyping that could affect a face-to-face interview. Do not openly refer to unsocial hours or mobility concerning gender, or assume that childcare arrangements would affect women only. Do not request the age of an applicant, either directly or by indirect questioning, the date they left school, etc. Records should always be kept of the interviews to determine how applicants are scored and assessed. Adjustments for candidates with disabilities. Where realistic, adjustments should be considered in a business to ensure that job roles are available to disabled candidates during the recruitment process. This can be achieved by providing large print and braille statements for those with visual disabilities, ensuring that all locations for candidates have wheelchair access, preparing quiet areas for candidates who have hearing impairments, arranging access for a helper if a candidate has a learning disability, providing large print handouts for a candidate with a visual impairment. Selection. When utilizing selection tests or exercises during recruitment, they should be reviewed regularly to ensure a lack of bias or discrimination. They should also be checked to confirm. Selection scoring is based on skills, experience, knowledge, qualifications, and competencies, and not any other preferences. If adding more interviews will make scoring fairer and less biased. The selection process remains straightforward and a fair continuation process for the criteria specified in the recruitment process so far, with accurate marking methods. Automated decision-making. Some businesses have begun to use automated decision-making software. This makes decisions based solely on parameters entered by the applicant. If an employer makes a qualifying significant decision based only on the software, they must tell the candidate as soon as possible according to requirements under the Data Protection Act 2018. The candidate must be notified in writing as soon as possible of the decision, to allow them to appeal the decision. Once informed, the candidate can contact the employer to review the decision, or request an alternative interview not using automation. The employer then has to respond to the request as appropriate. This is to combat any discrimination that may be inherent in the software. Making an offer of employment. Once the employer has identified an applicant for a job candidate, several things need to take place. The employer needs to identify the terms and conditions that will be presented in an employment contract. A job offer should clearly state the start date and any other terms and conditions to be agreed on. At this stage, discriminatory terms may be unlawful and void. Special conditions, such as probation, should be made clear with the job offer. Further requests regarding identity and other information should be made clear with the offer. Terms and conditions should be recorded in writing if possible. Dates of agreements and signatures need to be recorded. Carrying out checks on potential employees. As previously mentioned in this module, despite data protection and personal privacy, a business must carry out several checks to ensure that a job candidate is appropriate for the offered role. Right to work in the UK. By law, an employer may only recruit and hire an individual who has permission to live and work in the UK. The following factors also need to be considered. Citizens from the EU and Swiss nationals have the automatic right to work in the UK under the Freedom of Movement Act until the process of Brexit has completely concluded all negotiations with the EU Council. Following settlements, and as of the 31st of December 2020, EU citizens can remain in the UK indefinitely if they have applied for settled status, after living and working here for at least 5 years. Non-EU migrants will require permission to enter and work in the UK. They are subjected to the points-based system, PBS. Under the Immigration Act 1986, employers can be given 5 years in prison and an unlimited fine for employing an illegal worker. Employers are legally obliged to carry out all possible checks on an applicant to ensure that they are legal to work in the UK. Medical checks. Employers should understand that their applicant is medically fit and able to perform their job role. However, the following factors also need to be considered. Under the Equality Act, it is possibly discriminatory to perform a medical check on an applicant before making a job offer. An employer can ask questions to ascertain if an applicant is intrinsically capable of performing job specifics or is agreeable to perform a selection test based on requirements. Employers can request a receipt of a recent medical report to prove physical capabilities if this is proven to be necessary. In most recruitment processes, a simple health questionnaire should be enough. Qualifications. Employers should only insist on specific academic qualifications if they are genuinely required for a job role, and they can prove this is the case in a tribunal. Otherwise, employers should also consider that applicant can provide documented proof of their qualifications with a valid certificate or degree notice. That overseas applicant may hold relevant qualifications in different academia from those in the UK. Overseas qualifications can be easily assessed by contacting the National Academic Recognition Information Centre, NARIC. References. There is no legal precedent for an employer or employer to produce references for job applications. However, it is a long-established practice, and some industry and regulatory bodies request employers obtain and provide references for employees. Employers are legally obliged to provide true and accurate references for an employee. If an ex-employee can establish that a refusal to produce a reference is down to personal or negative opinions, a claim for personal discrimination can be filed. Restrictions on the employment of children and young persons. UK laws are in place to prevent the exploitation of younger people. In further detail, school leaving age. A child is an individual who is not over compulsory school age, which means someone under the age of 16. A young person is an individual who is over the minimum school leaving age, 16, but has not yet turned 18. The Education and Skills Act 2008 states that young people should continue in education or training until 18. So those between 16 to 18 are mostly involved in further education or work-based training. School leaving age still refers to 16 years. Restrictions on the employment of children. No child can be employed on a site where heavy work is occurring, materials are being transformed. Many local authorities ban the employment of children anywhere that sells alcohol or dangerous chemicals. UK law does allow children over 14 to participate in light work in some offices, shops, or farms. This employment should avoid school and unsocial hours, last less than 8 hours in a day, and be less than 4 consecutive days. These restrictions do not apply to work experience jobs that have been approved by local authorities. When employing a child, the employer must have an employment certificate, which has been approved by the local authority. General exceptions to working hours for young workers. Young people have the same rights as adult workers as regards discrimination in the workplace. UK law, the Working Time Regulations 1998, does place timing restrictions on the hours that young people can work. Employers cannot make young people work more than 8 hours a day or more than 40 hours in a week. They must also be given adequate rest periods. Daily equals 12 hours, consecutive rest must be given every 24 hours. Weekly equals 48 hours each week must be ensured, but can be reduced to 36 for justified reasons. This may be reduced to 36 hours if necessary. Rest breaks equals a 30-minute rest break during any shift lasting more than 4.5 hours. Night equals they must be supervised and cannot work between midnight and 4 a.m. Health assessment should include considerations as to whether a young person has the physical and psychological ability to do the work. The right to time off for paid study. Employees between 16 or 17 years old have the right to claim paid leave to spend time studying or training. This is to allow them an additional chance to gain suitable qualifications. Employees who are 18 are also allowed that leave, assuming they started training before their last birthday. This directive only covers qualifications that are sourced and approved by NVQ, National Vocational Qualification, bodies. The leave should be judged to be reasonable, with a normal hourly rate. An employer can be reported to an employment tribunal if they refuse the time off without good reason. Employer's Guide to Criminal Record Checks. If a job applicant has a criminal record, it does not automatically prevent individuals from procuring that role. The employer's decision should be non-discriminatory and depend upon the nature of the criminal offense, the circumstances it was committed to, the type of job being offered, the length of time since the act took place. With that information in hand, an employer should make an unemotive decision about whether it is appropriate for the business and role to hire that applicant. It is unlawful for an employer to treat an applicant less favorably because of a spent conviction where a defined length of time has elapsed after a sentence has been completed. Unless the criminal act was serious enough for an exceptions order, the employee does not have to reveal the existence of a spent conviction. Employers can officially request details of employees' criminal records through the Disclosure and Barring Service (DBS). Summary. In this module, we have covered the following points. It can be easy to discriminate against a section of society during the job recruitment process, without even being aware. Only specify requirements for gender, religion, etc. in a job application if it is truly warranted to the operation of the role. Employees must be honest when submitting personal details. Decisions in interviews must only be based on skills and knowledge, and not personal impressions or characteristics. Employers must ensure that applicants have the legal right to work in the UK. Employers should not let criminal records influence their opinion of a job applicant.